Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. Over the past 3 lectures, we've built a complete framework for trade secret protection, the 6 pillars, how to implement them, and how to sustain them through ongoing governance. We've explored the practical realities of making protection plans work, from accountability structures to resource allocation, from metrics to adaptation. But we haven't yet addressed a fundamental question. Why do we need trade secret law at all? Why aren't contracts enough? Why can't businesses just rely on non-disclosure agreements, employment agreements, and vendor contracts to protect confidential information? After all, contract law is well established, enforceable, and flexible. If two parties agree to confidentiality, why does the law need a separate body of trade secret doctrine? This lecture explores that question, not as an abstract theoretical exercise, but as a strategic inquiry that shapes how counsel advises clients, how businesses allocate protection resources, and how courts balance competing interests in innovation, competition, and employee mobility. The answer lies in network theory, specifically the distinction between dense networks and sparse networks. In dense networks, where parties interact repeatedly, reputations matter, and social norms enforce cooperation. Contracts and informal mechanisms often suffice. Trade secret law adds little marginal value, but in sparse networks, where transactions are one-time, parties are dispersed, and reputational sanctions don't work, trade secret law becomes essential. It fills gaps that contracts can't reach and norms can't enforce. This lecture draws on foundational work by Ronald Gilson, Robert Mnookin, and others who've explored how legal infrastructure shapes innovation ecosystems. We'll examine Silicon Valley as the paradigmatic dense network, contrast it with sparse transactional markets, explore how trade secret law creates in rem rights that bind third parties, and discuss the policy implications. Should trade secret law expand to protect more information, or should it contract to preserve employee mobility and competition? By the end, you'll understand when and why trade secret law matters, and when it doesn't. Let's begin with the foundational question. Contracts are powerful. They bind parties who sign them. They create duties of confidentiality, limit use, impose remedies for breach. Employment contracts can prohibit disclosure. Vendor agreements can restrict sharing. Licensing deals can segment markets. So why do we need a separate body of trade secret law? The answer is that contracts create in personam rights, rights enforceable only against specific parties who agreed to them. If you sign an NDA with me, you're bound. But if you share my secret with a third party who didn't sign anything, I can sue you for breach of contract. But I may have no claim against the third party. They're not in privity. They never agreed to anything. Trade secret law solves this problem by creating in rem rights, rights that run with the information itself, binding anyone who misappropriates it, regardless of whether they signed a contract. If you steal my trade secret, or if you receive it knowing it was stolen, or if you acquire it through improper means, I can sue you under UTSA or DTSA, even if we've never had a contractual relationship. This distinction matters most when secrets travel beyond the original parties. Consider a common scenario. Company A shares confidential information with vendor B under an NDA. Vendor B's employee leaves and joins competitor C, taking the information with them. Competitor C uses it to develop a competing product. Under contract law alone, Company A can sue vendor B for breach. The employee violated B's internal policies, which may trigger B's liability under the NDA. But Company A may have no direct claim against competitor C. There's no contract, no privity, no direct relationship. Under trade secret law, Company A can sue competitor C directly for misappropriation, because trade secret law doesn't require privity. It imposes a duty on anyone who acquires confidential information through improper means or in breach of a duty to keep it confidential. The law follows the information, not just the contract. This is the core value proposition of trade secret law. It protects secrets from third parties who never agreed to anything. But that value proposition isn't uniform across all business contexts. In some environments, contracts and social norms do most of the work. Trade secret law is backup. In others, contracts fail, norms don't apply, and trade secret law is the only meaningful protection. Understanding which environment you're in shapes how you allocate resources. The distinction between dense and sparse networks comes from economic sociology and law and economic scholarship, most famously articulated by Ronald Gilson in his 1999 article, The Legal Infrastructure of High Technology Industrial Districts. Gilson was trying to explain why Silicon Valley succeeded where other regions with similar resources, universities, and capital failed. His answer: dense networks with high rates of job mobility, frequent interactions, and reputational enforcement mechanisms created self-sustaining innovation ecosystems. Trade secret law mattered less than social norms. Dense networks are characterized by repeat interactions. Parties expect to deal with each other again, either directly or through mutual connections. Reputational stakes. Bad behavior gets punished through social sanctions, lost deals, damaged credibility, exclusion from future opportunities. Shared norms. Industry conventions, ethical standards, and informal rules guide behavior even without contracts. High visibility. Misconduct is likely to be discovered and discussed within the network. In dense networks, trust is self-enforcing. If you steal someone's idea, word spreads. Investors won't fund you. Talented employees won't join you. Partners won't work with you. The reputational cost exceeds any short-term gain from misappropriation. Sparse networks are the opposite. One-time transactions. Parties don't expect future dealings, so reputational sanctions don't apply. No shared community. Participants operate in different markets, industries, or geographies, so word doesn't spread. Weak norms. There's no common understanding of what constitutes fair play, and enforcement depends on law, not social pressure. Low visibility. Misconduct may never be detected, or if detected, may not reach others who might sanction it. In sparse networks, legal enforcement is essential. Without it, parties have no reason to respect confidentiality. Contracts might create obligations, but third parties aren't bound, and reputational effects don't matter if the parties never interact again. The key insight: trade secret law adds value primarily in sparse networks, where contracts and norms fail. Let's see how this works in practice. Silicon Valley is the paradigmatic, dense network. Entrepreneurs, investors, engineers, and executives cycle through a small, interconnected ecosystem. Today's founder was yesterday's employee. Today's investor funded yesterday's competitor. Today's partner may be tomorrow's acquirer. This density creates powerful, self-enforcing mechanisms. Consider the pitch meeting. Entrepreneurs routinely share confidential business plans, technical insights, and market strategies with venture capitalists, often without signed non-disclosure agreements. Why? Because VCs who steal ideas don't stay in business. Word spreads. Entrepreneurs blacklist them. Co-investors avoid them. Deal flow dries up. The same logic applies to employee mobility. Engineers move frequently between companies. They carry knowledge with them, sometimes general skills, sometimes specific insights. Trade secret law could restrict this mobility through inevitable disclosure injunctions or aggressive litigation. But Silicon Valley culture rejects those tactics. Companies that sue departing employees aggressively get reputational blowback. Talented workers avoid them. Gilson argued that California's refusal to enforce non-compete agreements contributed to Silicon Valley's success. By allowing employees to move freely, California created an environment where knowledge circulated rapidly, innovation accelerated, and startups could recruit talent from incumbents. Trade secret law still existed, but it operated in the background, invoked rarely, and constrained by norms favoring mobility. In this environment, reputational enforcement substitutes for legal enforcement. If you misappropriate a trade secret, you might win a short-term advantage, but you'll lose long-term access to the network. That trade-off doesn't make sense. So most actors behave cooperatively, even without contracts. Hollywood exhibits similar dynamics. Writers pitch scripts to studios without formal protection. Studios could steal ideas, but they don't, because writers would stop pitching to them, agents would blacklist them, and the industry would exile them. The network enforces confidentiality through social sanctions. not lawsuits. Does this mean trade secret law is irrelevant in dense networks? Not entirely. It provides a backstop, a legal remedy for egregious violations that breach norms so badly that reputational sanctions aren't enough. But it's not the primary enforcement mechanism. Norms do most of the work. Now consider a sparse network. A manufacturer shares proprietary specifications with an overseas supplier. The supplier is located in a different country, operates in a different legal system, and has no expectation of future dealings with the manufacturer. There's no shared community, no reputational stake, and no social norm that binds them. In this environment, contracts alone may fail. The manufacturer can draft an NDA, but enforcement across borders is costly, uncertain, and slow. The supplier may comply or may not. If they share the specifications with a third party, another manufacturer, a competitor, a government entity, the original manufacturer has limited recourse. This is where trade secret law adds essential value. The DTSA provides federal jurisdiction, nationwide, and increasingly international enforcement, and remedies that don't depend on the defendant having signed a contract. If the supplier misappropriates the secret, the manufacturer can sue under DTSA in U.S. federal court and potentially recover even if the supplier never formally agreed to confidentiality. Similarly, consider employee departures to non-competitors. Employee leaves Company A, pharmaceutical, to join Company B, medical devices. The companies don't compete directly. There's no repeat interaction, no shared industry norms, no reputational enforcement. If the employee shares Company A's secrets with Company B and Company B uses them, Company A has no way to sanction Company B through reputation. The only remedy is legal. Trade secret law fills this gap. It imposes a duty of confidentiality that survives employment and operates beyond contract. Even if Company B never signed an NDA with Company A, if Company B knowingly receives misappropriated information, they're liable under trade secret law. One-time vendor relationships are another classic sparse network. A startup shares code with a development vendor for a single project. The vendor completes the work, gets paid, and disappears. No future dealings, no shared network. If the vendor later sells the code to a competitor, the startup's only recourse is trade secret law, because contract enforcement across jurisdictions may be impractical, and reputational sanctions don't apply when the parties never expected to interact again. The lesson: in sparse networks, trade secret law is the primary enforcement mechanism, not the backstop. The distinction between dense and sparse networks maps onto a fundamental legal concept: in rem versus in personam rights. In personam rights, personal rights bind specific individuals. Contracts create in personam rights. If you sign an NDA, you are bound. But third parties who never signed aren't. Courts can enforce the contract against you, but not against them. In rem rights, property rights, bind everyone. Trade secret law creates in rem rights, or at least quasi-property rights. If information qualifies as a trade secret, anyone who misappropriates it, through theft, breach, or improper means, can be held liable, even without privity. This distinction explains why trade secret law matters most in sparse networks. When parties interact once and never again, contracts create obligations between them, but those obligations don't extend to third parties. If the secret travels beyond the original parties, as secrets often do, contract law fails. Trade secret law picks up where contracts stop. The policy debate over trade secret law often centers on this tension. Should trade secret law create strong in rem rights, protecting secrets broadly, even at the cost of restricting employee mobility and competition? Or should it create weak in rem rights, allowing more information flow, even at the cost of less protection for innovators? There's no universal answer. The optimal balance depends on the network structure. In dense networks, strong trade secret protection may be unnecessary and counterproductive. It restricts mobility, slows information flow, and substitutes rigid law for flexible norms. In sparse networks, weak protection may be insufficient. Without legal deterrence, parties have no incentive to respect confidentiality. This theoretical framework has practical implications for how courts, legislatures, and businesses think about trade secret protection. Expansionists argue that information is increasingly valuable mobile, and vulnerable. In a globalized, digitized economy, secrets travel faster and further than ever. Sparse network transactions dominate. One-time vendor relationships, cross-border collaborations, gig economy contractors. Trade secret law must expand to protect innovators who can't rely on repeat dealings or reputational enforcement. The DTSA reflects this view. By creating federal jurisdiction, ex parte seizure, whistleblower protections, and enhanced damages, Congress signaled that trade secrets deserve stronger, more uniform protection, especially against sophisticated actors who operate across state lines or internationally. Skeptics argue that overprotection stifles competition, restricts employee mobility, and creates litigation abuse. If trade secret law becomes too broad, companies can use it to lock up general industry knowledge, prevent employees from changing jobs, and extract settlements from competitors based on speculative claims. California's refusal to enforce non-compete agreements and its court's skepticism of inevitable disclosure injunctions reflects this view. The policy choice is to prioritize mobility, competition, and knowledge diffusion over absolute secrecy. The DTSA tried to split the difference. It strengthened protection, federal jurisdiction seizure, but also constrained it, whistleblower immunity, explicit prohibition on employment-based injunctions that prevent working. The statute acknowledges that trade secret law must protect innovation and preserve competition. Where does this leave counsel advising clients? In dense networks, invest in reputation and relationships, not just legal protection. Build trust, enforce norms, and participate in the community. Trade secret litigation should be rare, a last resort when norms fail. In sparse networks, invest in legal protections, robust non-disclosure agreements, DTSA compliant agreements, technical controls, and documentation systems. Reputational enforcement won't work. Legal deterrence is essential. Across all networks, recognize that trade secret law complements but doesn't replace contracts. Contracts create baseline obligations. Trade secret law extends them to third parties. Both are necessary. Neither is sufficient alone. Let's recap. Trade secret law exists because contracts aren't enough. Contracts create in personam rights, binding only the parties who sign them. Trade secret law creates in rem rights, binding anyone who misappropriates information, even without privity. But trade secret law doesn't add equal value in all contexts. In dense networks, like Silicon Valley or Hollywood, repeat interactions, reputational stakes, and social norms enforce cooperation. Trade secret law operates in the background, invoked rarely. In sparse networks, one-time vendor deals, cross-border transactions, employee departures to non-competitors, legal enforcement is essential because contracts don't extend to third parties and reputational sanctions don't apply. This framework helps counsel advise clients strategically. In dense networks, invest in relationships and norms. In sparse networks, invest in legal protections. Across all networks, integrate contracts and trade secret law. They're complements, not substitutes. The policy debate, whether to expand or constrain trade secret protection, reflects this tension. Expansionists emphasize the need for stronger protection in globalized, sparse network economies. Skeptics warn that overprotection restricts mobility, stifles competition, and enables litigation abuse. The DTSA attempted a balance, stronger enforcement tools paired with explicit limits on employment restrictions. Understanding when and why trade secret law adds unique value beyond contracts, beyond norms, is what separates sophisticated counsel from those who treat protection as a compliance checklist. Trade secret law isn't just doctrine, it's strategy, and strategy depends on context. This concludes Module 7 and the entire lecture series. You've now covered the foundations of trade secret law, how to identify and value secrets, how to mitigate internal and external risks, how to enforce rights, and how to synthesize everything into a comprehensive, sustainable protection plan. You've learned not just what the law requires, but why it exists and when it matters. Trade secret protection isn't a project. It's a discipline. It rewards diligence, integration, and continuous attention. Courts don't protect secrets. You protect secrets. courts protect you if you've done the work. Thanks for listening. Good luck building systems that last.